Hey everyone, Mike Harris, Director of Public Policy for Gun Owners Action League. And before I get to the good news that Dan Hagan and I are going to be discussing on Friday about the landmark Santana Rodriguez decision, I have a little bit of bad news. And it comes in the form of Commonwealth v. Erler. This was a case from attorney Bill Smith, and it has to do with the responsibility of a defense attorney, especially a court-appointed one, when it comes to your Second Amendment civil rights when you're dealing with an OUI charge. This is a little bit of background. So a prohibitive charge that will make you a prohibited person on a federal level is any conviction in any court of a crime punishable by imprisonment for a term exceeding 1 year. That makes you a prohibited person. It doesn't have to be a felony or a violent crime that you're charged with or convicted of, I should say, but just it has to do with the penalty when it comes to being a federally prohibited person. So here in Massachusetts, your first OUI has a felony equivalent potential penalty. You can get up to 2.5 years in jail for your first conviction of an OUI. So conviction also means like pleading guilty or, getting a lesser penalty. So if you just get probation or you just get a fine or something like that, you're still convicted and your potential penalty was up to 2.5 years. So that makes you a prohibited person in Massachusetts. It's not really clear if that was the intent behind the change. We had things like Melanie's Law and zero tolerance laws that came into effect, between 1998 and 2005 that kind of changed the penalties. But in this circumstance, the Attorney Smith has a blog post that he put out on his gunlawyer.blog page, and I'll post that down below, and we're going to put that in Friday News and everything as well, so everybody can take a look at it. But it's really well written. It's Massachusetts Appeals Court holds your Second Amendment rights are merely collateral, which is kind of the case. On October 10th of this year, 2025, the Massachusetts Appeals Court held in a shocking decision, Commonwealth v. Erler, that criminal defense counsel in Massachusetts does not necessarily have to warn their clients about the consequences of a plea of guilty in cases relative to your right to keep and bear arms. Just a quick breakdown from his blog. In the early hours of January 6, 2022, the defendant was observed on Route 1 in Massachusetts swerving between lanes. State trooper stopped them, smelled alcohol, all that. They were charged, tried, and convicted of OUI under Mass General Laws, Chapter 90, Section 24(1)(a)(1). After the conviction, the defendant moved for a new trial on the grounds that his lawyer should have advised him about options such as quaffs, continuing without a finding, and the firearms possession consequences of a DUI conviction. His lawyer admitted that he knew the client had a license to carry, an LTC, but did not discuss the repercussions of conviction versus alternative dispositions and the right to maintain his license. So the appeals court, upon the appeal that just occurred on, or the decision was just issued on the 10th. The appeals court rejected the claim of ineffective assistance of counsel, holding that collateral consequences, your Second Amendment rights, of a plea or conviction on firearms possession does not automatically amount to ineffective assistance. They also found that the evidence sufficient to uphold the OUI conviction and held that the trial judge acted within his discretion in admitting certain evidence, things like that. So this just means that even if you're appointed a criminal defense attorney by the court in this criminal trial, they do not have to tell you now that there is a potential for you to lose your ability to possess firearms in the Commonwealth if you are convicted of an OUI, and that includes a plea deal of guilty. So this is just a small thing, but it's something that we feel our members should know. Just in case you do find yourself in that situation, it's now up to you to decide that whether or not a guilty plea is worth it, or if defending your civil rights is worth going to court and spending the money over. It's really it's a real Sophie's choice in this case. DUIs are not treated with kid gloves in Massachusetts unless you're a certain type of politician. But yeah, like I said, I will post the full blog below this. But if you want to check out Bill Smith's page, it's gunlawyer.blog. He he writes some excellent stuff. He's fantastic on Second Amendment rights stuff in Massachusetts, and we're gonna, I think it's important for everyone to check out this page and to be aware of your rights if you find yourself in that situation. Your attorney doesn't have to tell you in Massachusetts under the this new decision by the appeals court. So yeah, thanks a lot. Have a good one. Bye.